All right, let's talk about one of the messiest, most important questions in property law. When a relationship breaks down, whose house is it? This isn't just about who gets the sofa. This is a situation that can get incredibly complicated, and it happens all the time.
So picture this. You've poured your money, your effort, your life into building a home with someone. But for whatever reason, your name isn't on the legal paperwork, the deed. When you split up, what happens? Do you just walk away with nothing? Well, thankfully, the law has some pretty fascinating and, complex ways of dealing with this.
You know, this whole thing really boils down to one key idea: beneficial interest. It's a huge deal. It separates who owns the property on paper from who actually has the right to enjoy it. So think of it like this. The legal owner might hold the physical keys, but the law cares about the beneficial owner, the person who has the right to live inside and call it home.
Now look, in a perfect world, there's a super simple solution to all of this. It's called an express trust. It's just a written document signed by everybody involved that spells out exactly who owns what share. Honestly, it's the gold standard. If you have one of these, you avoid all the drama we're about to get into.
But let's be real, life is messy, and most couples don't have these formal legal documents. So what happens then? Well, this is where the courts have to step in and find a fair solution. And their main tool for doing that is something called an implied trust. It's basically the law looking at the situation and saying, okay, nothing was written down, but based on how you guys acted, we're going to create a trust to reflect what you intended.
So the first type of implied trust we're going to look at is the resulting trust. And it's based on a really simple principle: money talks. The law basically presumes that if you hand over a chunk of cash for a house, you probably weren't just giving it away as a gift.
The logic here is super straightforward, right? Step 1, you contribute cash to buy the house. Step 2, your name doesn't end up on the deed. So step 3, the law just automatically presumes that the person whose name is on the deed is holding a piece of the property for you. And the crucial part, your share is directly tied to your contribution. You put in 25% of the money, you get 25% of the beneficial interest. It's simple math.
But, and this is a big but, it's just a presumption. It's not a concrete rule. And it can be knocked down if there's evidence that the money was actually a gift, or maybe it was just a loan you were meant to pay back. There was also this old-fashioned idea of advancement, where money from a husband to a wife was presumed to be a gift, but that's pretty outdated now.
And here's where the story takes a really interesting turn. For a long time, resulting trusts were the go-to for sorting out shares in a family home. But then, a massive case called Stack v. Dowden came along and completely changed the game. The courts basically said, look, family life is way too complicated for this simple money in, share out approach. So now, resulting trusts are mostly just for business or commercial property deals, not for the family home. So if resulting trusts are out for family homes, what's in? Well, that brings us to the second and much more flexible tool, the constructive trust. This one isn't just about cold hard cash. It's about looking at the entire relationship, the promises that were made, the actions that were taken, the whole story, to figure out what's fair.
So, how does a court construct one of these trusts? It's on the lookout for two key ingredients, which you can see right here in this formula. First, there has to be a common intention, some kind of agreement or understanding that you would have a share. And second, you have to have relied on that understanding to your detriment. Let's break down what those two things actually mean.
All right, let's tackle that first ingredient, common intention. The easiest way to prove this is if there was some kind of express discussion. We're not talking about a formal contract. It could just be a conversation you had that shows you were both on the same page about sharing the property.
And the real-life cases here are just wild. Take a look at this quote from a famous case, Eves v. Eves. The guy told his partner her name couldn't go on the deed because she was under 21, which, by the way, was a total lie. It was just an excuse.
But here is the absolute genius of the court's decision. They said the fact that he felt he needed to make up an excuse proved there was a common intention to share. Why else would you need to lie about it? The excuse itself was the best evidence that he knew deep down she was supposed to have a share. Incredible, right?
And this wasn't a one-off thing. We see the exact same logic in another case, Grant v. Edwards. This time, the excuse was that putting her name on the title would mess up her divorce proceedings. And just like before, the court said, aha, that excuse proves you both knew she was meant to be a co-owner. Okay, so you've got the promise, or the understanding. But that's only half the formula. You also have to show you acted on it in a way that was to your detriment. Basically, you did something significant you wouldn't have done otherwise. In that Eves case, she did a ton of heavy-duty renovation work. We're talking wielding a sledgehammer.
But it could also be something like giving up your own apartment to move in, or even deciding to spend your savings on a new car because you thought you had a secure home for life. Okay, but what if there were no conversations? No excuses, no explicit promises, nothing said out loud. This is where things get even trickier. This brings us to the second kind of constructive trust, where the court has to imply the common intention just from how people behaved.
And wow, the law here has gone through a massive evolution. For a long time, the rule from a case called Lloyds Bank versus Rossett was brutally strict. Courts could only look at direct financial contributions to the purchase or mortgage. This led to some truly heartbreaking outcomes, like in Burns versus Burns, where a woman gave 17 years of her life, raised the kids, paid for all sorts of things, and walked away with absolutely zero. But then, in 2007, Stack v. Dowden came along and caused a legal earthquake, starting a whole new, much fairer era.
This table lays it all out, crystal clear. The old Rossett approach was narrow. It only cared about direct payments. The result? Rigid and, let's face it, often deeply unfair. The modern Stack approach is the complete opposite. It forces the court to look at the whole course of dealing. That means everything. How you managed your finances, whether you had kids, why you bought the home, the nature of your relationship, the whole shebang. It moved the law from a simple calculator to a holistic search for genuine fairness. Okay, so let's say you do it. You go through the fight, you prove a trust exists, and you win. Now for the million-dollar question, what's your share? What do you actually get at the end of all this?
Well, again, it totally depends on the type of trust. For a resulting trust, it's that clean, simple math. Your share equals your cash contribution. Easy. But for a constructive trust, if there was never a discussion about specific shares, the court has a much tougher job. It has to look at that whole course of dealing all over again and decide what share would be fair.
This chart helps you see the difference. With a resulting trust, you get a fixed slice of the pie, say 25% if you put in 25%. But with a constructive trust, the court is essentially drawing the lines on the pie itself. It's deciding how big your slice should be based on the entire story. This makes the final outcome much harder to predict.
And this really hits the nail on the head. A quote like this just shows you the reality. These cases force people to dredge up conversations from years ago, to argue over who said what, when, and why. It's emotional, it's difficult, and as the quote says, it's a breeding ground for long, expensive legal fights.
So, what's the bottom line here? The law of implied trusts is an absolutely vital safety net. It's there to stop people from being treated unfairly. But it is not a simple fix. It is a complex, expensive, and emotionally draining process, and the outcome is never, ever guaranteed.
Which brings us right back around to the ultimate question you have to ask yourself. The law has spent decades trying to create a safety net for these messy situations. But is relying on that complicated, unpredictable, and costly net really worth it? Or is the best protection you can have simply having that open, honest conversation and getting everything down in writing, right from day one?